Wonderful. Good afternoon or good morning. Happy lunch and brunch. We appreciate you joining today for our HUD Series 101 on accessibility, property compliance, and your property. So just a few housekeeping events as we have people joining us here. If you remember, along the right-hand side, you have some options there for chat as well as question and answers. If you do have questions, this series here today, we really want it to be interactive. So we'll pause and have some questions addressed throughout the presentation. But please put those in the questions. That way we can keep things moving and make sure we don't miss any of your questions along the way. Our team here at Lumina Compliance really focuses on a team approach and a partnership approach with asset management inspections, accessibility, Section 504, fair housing compliance, capital needs assessments, and due diligence, as well as file reviews. And the purpose of these times and this lunch, brunch, and learn is really to give back and give you some education, answer your questions along those topics, and bring up some updates as well that happen as we attend various association meetings such as NAMA and the other affordable housing conversations that we're having throughout the country. So our team, we've provided over 15,000 physical inspections and growing over the years here, as well as not only to management companies and developers, but owners and housing authorities, syndicators, really any player within the multifamily or affordable and conventional aspect. So with that, I want to introduce our founder and CEO, the gentleman who's going to be leading today's conversation. He has over 40 years of experience in the affordable housing industry, and he's not only been on this side of it, but he's actively in your shoes with development, management, and I think throughout his career has pretty much touched every facet of affordable housing, whether that be HUD properties tax credit, rural development, and so I know that he's been a mentor and just guide throughout the industry for many people, but for me personally, he's definitely one of my key mentors in this industry. Love partnering and working with him and the team every day. But with that, I know he's going to do a fantastic job walking us through, answering your questions. Don't be afraid. Please post those. And I guess with that, Greg, I'll hand it off to you.
Thanks, Andy. I've gotten the point now, and I think I've said this before in some of these sessions, that I need to kind of pull back on the number of years that I've been in the business, because that just tells people that I'm somewhere probably in advance of 50 or 60 years old. So that I need to kind of reconsider. But thank you guys for being here today. The HUD side of accessibility is something that I really am excited about, simply because this is where I got my start on fair housing and accessibility. And we'll talk a little bit about that in a minute. But basically what I wanted to kind of emphasize during this session today is that, everybody thinks of accessibility and they think it's kind of a singularly focused, but the fact is properties have so many different variables in how they have to be in compliance. And so, that's what I really want to point out today is making sure that you understand what kind of issues you're having to deal with, and you understand there's nuances to whether or not your property was built in the 70s or whether it was built in the 2000s, whether you have assistance. And obviously, if you're here on a HUD session, you probably have federal assistance on your property. But all those kind of things play into what is making your property either in compliance or out of compliance. So to that point, your property falls into several categories. It falls under several laws, regulations, and it really is determined by whether or not you have assistance and what the age of your property is. So let's go a little bit into what kind of regulations are at play here. There was obviously the Civil Rights Act of 1968 that created the protected classes of race, color, religion, sex, and national origin. Now, in 1988, that's a long time ago, 1988, the Fair Housing Amendments Act came into play, and that basically created a whole different set of regulations for properties that were built or CO 1391. If you have a leasing office at your property or any other type of public accommodations, then ADA is going to apply to it as well. And on top of that, and primarily where we focus today for a HUD session is Section 504. Section 504 is effectively a regulation that requires certain aspects of the property and your programs to be accessible. And we'll talk about that as well. Sometimes you'll have state and local codes as well who will that will effectively add a different set of regulations. And you're going to want to make sure that in any case that the most stringent and strict guideline is the one you use. So as you can see, you could have a property that has just no HUD assistance, and that would be just and built after 1991, and that'd be a Fair Housing Amendments Act property. If you have that leasing office and parking, you're going to fall under ADA. And then if you have a property that was built after 1991, has public accommodations, and is federally assistance, you can see that in that diagram, it's going to cover all three of those, and all three of those laws are going to affect your property. So the best way for me to kind of tie them all together is, you'll hear Section 504 at your property, and that's going to happen because you typically with the HUD property have federal assistance or some sort of insurance or something that causes you to have to follow Section 404. ADA is going to apply to your leasing office. And then Fair Housing Amendments Act is going to apply to any property built after 1991. So a couple things that I want to real quickly point out about ADA and Fair Housing Amendments Act. I really want to spend most of the time today talking about Section 504. But I do want to mention a couple things about ADA. ADA was signed into law in 1990, and it's separate than Section 504. And Title III of the Act basically is saying that if you have a public accommodation, you may not discriminate. And so in the physical aspect of things, discrimination comes into play as it relates to accessibility. If you can't get from your car to the leasing office, then your property is not accessible for ADA purposes. One of the other things I did want to mention to you is that in a lot of ways, the regulations for ADA, they have their own regulations, and the regulations that apply to Section 504, they use the Uniform Federal Accessibility Standards, or UFAS, are very similar, but the only place they really diverge tremendously is with parking. And so the main thing you need to worry about as it relates to ADA is that the parking spaces are going to have a different type of setup as opposed to a regular accessible parking space. As you can see on the slide in front of you, a typical accessible space is an 8-foot wide parking space and a 5-foot wide access aisle, and you can see that on the left side of the diagram in front of you. For ADA, you typically have a same 8-foot wide parking space, but you have an 8-foot wide access aisle. Now that also can be a 11-foot parking space and a 5-foot. I mean a 8-foot parking space and 11-foot parking space and a 5-foot access aisle. So the new ADA regulations allow you to actually, have a 8-foot wide parking space and an 8-foot wide access aisle, or a 11-foot parking space and a 5-foot access aisle. So either way is fine. It all ends up equaling 16 feet, which is what they're requiring. So either way you do that is perfectly okay. So that's the main thing for properties that have public accommodations. Another thing to remember about ADA is if you have a leasing office, obviously everybody would probably know that that's a public accommodation. But if you have a community space or something that you rent out to the general public, then that's going to fall under ADA as well. So make sure that you are, if you are renting out your community area or something on your property to the general public, that you have that be accessible as well, not just your parking. So let's talk real quickly. I'm not going to spend a whole lot of time on the Fair Housing Amendments Act. If you have some questions about that, we have several sessions previous to that are on our website that will allow you to kind of take a deeper dive into this. But I real quickly want to just talk about it. Most of you out there, your properties, if you're HUD property, most of them were not built after 1991. So the Fair Housing Amendments Act does not apply. But if you do have a property, a HUD property that was built after 1991, then these 7 guidelines would apply. So as we were talking, the Fair Housing Amendments Act was added in 88, and it added familial status and disability. So what it's saying is, if you have a property that's over 4 units, you must have it built with 7 design features. And that came into play for any property that CO'd after March 13th, 1991. So let's talk a little bit about those features. Accessible building entrance on an accessible route, accessible and usable public and common areas, usable doors, accessible routes into and through a covered unit, reinforced walls for grab bars, light switches, thermostats, and other controls have to be accessible. And then you've got to have usable kitchens and baths. We'll real quickly kind of show you some of those things. Obviously, you have to have an accessible building entrance on an accessible route as one of the design features. You have to have usable and accessible public and common areas. So in other words, if your property is built after 1991, you've got to have access to the laundry room and the leasing office and any other common areas, as well as to the units themselves. Usable doors. I mean, usable doors is a requirement in and of itself. Most people can see pretty quickly how narrow doors, less than 32-inch clear opening, is very difficult for somebody that's mobility impaired to go through. Just check some of your door frames into some of those units where they're smaller than probably 36 or 40 inches wide. Once you get into a unit, you've got to have it accessible not only into the unit, but through the unit to your bathrooms, to your bedrooms and kitchens. Obviously, your light switches, thermostats, and any other control need to be within proper reach ranges. And then you have to have reinforced walls for grab bars. Now, with Fair Housing Amendments Act, you do not have to have grab bars. You do not have to have a property be or a unit be completely accessible. You just have to have it adaptable with these design features. And one of those design features is reinforced walls. So that's one of the things we see quite often on our inspections is properties built after 1991 that do not have reinforced walls for grab bars, which kind of goes against the 7 design features. And the last thing you have to have is usable kitchens and bathrooms. So those are your kind of requirements for the Fair Housing Amendments Act. They're very similar in the requirements that Section 504 has. It just applies to properties that are built after 1991 and says that they have to be adaptable. So what you have with the Fair Housing Amendments Act is any property, conventional or assisted, has to have these features, not just a HUD or RD property. So let's get to the meat of where we are today with HUD properties. HUD properties are required to be accessible as it was stated in Section 504 of the Rehabilitation Act of 1973. Now, the interesting thing about the Section 504 is it was implemented by Rural Development, or RD, in 1982. So properties built after 1982 from RD have to be in compliance with Section 504. HUD did not implement these regulations until 1988. So any property that effectively was built after 1988 has to be built with Section 504 requirements. And the requirements, the specific requirements, or the important requirements that you need to understand is that that you have to have 5% of your units be completely accessible for mobility impaired residents. Now, an additional 2% have to be for hearing impaired residents. So those are the requirements that you have. So if your property was built after 1988, then you are required to have the 5% and 2%. So that's where most of the HUD properties have to deal with a lot of different regulations and citations. Now, if your property was built in 1982 or 1972, your property is not required to have 5% and 2% accessibility. You are required to continue to have the ability to do reasonable accommodations and reasonable modifications. So that's really important to understand.
Greg,
now,
just to interrupt you real quick to kind of, a question came in particular to that, to see if, can you use the same units as your accessible or your hearing impaired units? Can those be the same unit, or do they? That's
a great question. I should have kind of spelled that out, but no, you actually have to have 5% physically accessible and then 2% hearing and visually impaired. So it'd be separate, not together. So you can't combine those. So good question. So as it relates to where we are today, HUD came out in 1988 and said, hey, you've got to go out and do a self-evaluation of your property to see where it is from a compliance standpoint. Because remember, properties built prior to 1988 have some accessibility features to some extent, but nothing to have a regulation or a set of regulations like UFAS or ADA to explain to them what they need to do. So back in 1988, I started doing accessibility plans and self-evaluation transition plans. And it was a thing that I thought would be done probably only for a year, simply because once you get that accessibility plan done and you do your self-evaluation, and then you do a transition plan to transition to being in compliance, I figured it would be a one and done. But the fact of the matter is, this is still an issue today, and they're still requiring you to be completely accessible at these properties. Now, the interesting thing about this is that there's some factors in play that everybody needs to understand. But and so let me go real quickly through this, and these are going to apply to many of your properties simply because I would imagine that most of you have properties built prior to 1988, and then also some after 88. But just some things to make you understand about your specific property. Townhomes are not covered by fair housing laws. Townhomes are units that have a upstairs and downstairs, and so they do not have access effectively to the bedrooms. But one thing I do want to point out is if you do have a property that's solely townhomes, and a new property built after 1988 would not allow you to have a property after 1988 with just townhomes. They'd probably have, and many of you have properties that have an end unit that are one story and fall under accessibility guidelines. But one thing to really point out about Section 504 and townhomes is that even though townhomes are not under Section 504, you still have a leasing office that is a public accommodation and needs to be in compliance with ADA. A couple more of these slides, I just want to kind of give you a sense of what's gone on over the last few years. Early on in 1988 to about 1990-91, we had a situation where HUD said, hey, we need to make your properties accessible. But here's several examples of someone trying to make some property accessible without really good guidelines. And as you can see there's a accessible space, there's a ramp, but if you can see, the ramp is inside of the access aisle, and then it leads up to a 3 or 4 inch change of elevation at the walk, and then a 2 inch change of elevation at the threshold. So obviously this is not accessible. And as I mentioned in the previous slide, ramps cannot impede and infringe on the access aisle. You'll also see where there is accessible parking, but accessible parking is more than just a sign. You've got to have a sign, you've got to have an access aisle, and those features have to be done properly. Here's another example of, and this is probably my favorite example of doing things with good intentions, but bad consequences. This was a van accessible ramp so that somebody could get from a wheelchair into a van. Obviously, that is not going to be in compliance. We'll say to you that not all of your HUD properties have the ability or requirement to be accessible. And as I mentioned before, if it was built prior to 1988, you do not have a requirement to have your property be fully accessible, but you do have the obligation to do any kind of reasonable accommodation or modification as needed. As you can see there, that door is 27 inches wide with cinder block walls. There's no way to make that property or that unit accessible. And here's another example. It's just that bathroom you cannot make accessible. So, but just because your property was built prior to 1988, you need to make sure and do things that are do reasonable accommodations and modifications. So, Andy, I think that's all the slides I have. Have you got any more questions? I can't hear you.
Turn off my background mute here. We did have a few that came through. I think they're really pertinent to what we were talking about here. One, just to come off of that last statement, there was a question of, do we have to make 5% of the units accessible on a HUD property? So I know there's some elements that you touch base throughout the presentation, but are you able to, I guess, in a simple, matter-of-fact way, make that clear?
No, yes. I mean, I think we kind of covered that. One thing that I will say is that that make sure you understand when your property is built, and make sure that you do or do not fall under Section 504, because I mean, your properties prior to that time do not have to be 5%. The properties after do in fact have to.
Yeah. Along the lines of Section 504 and reasonable accommodations, can a resident request to park in an accessible space as a reasonable accommodation?
Well, that's one of the things we see a lot, especially in elderly properties, is there's a limited number of parking spaces. And the fact is, you have one elderly person have a reasonable accommodation to park close to the building, and you're going to have just about everybody asking for reasonable accommodations. Now, there's a difference between a reasonable accommodation for somebody to park close to a building and having a resident request an accessible space. And so you want to make sure that you understand whether they actually need an accessible space or a van accessible space, or they just want to be able to walk less distance to their building. Huge difference, because your accessible parking spaces are open to anyone. And I mean, even people from the outside visitors can actually park in there if they're open. So it's a very difficult issue. It's something that I've seen time and time again with elderly properties, is you get a lot of people fighting over a lot of spaces, and you can accommodate to a certain point, and at some point you just don't have the ability to accommodate anymore, and then you can have a waiting list or something like that.
Yeah. Another question is, how or does a HUD property, do they have to pay for those reasonable modifications and accommodations? I know that's...
Yes, I mean, that's something that is different between conventional properties and assisted properties. You really are required to make a reasonable modification or accommodation. And again, it's reasonable. I mean, you can't... A resident asking you to put an elevator in their unit is not a reasonable accommodation. It's too expensive and a financial burden. But if you've got somebody that needs a van, a ramp at their unit, if it is a conventional property, you still are required to allow that to happen, but they are responsible for paying. On HUD assisted or federally assisted properties, the property is required to pay for that modification if it is a reasonable modification.
Awesome. And I'm sure we can go into another webinar about reasonable accommodations and fair housing.
Let me tell you, the reason why I focus primarily on physical accessibility is that trying to figure out what is reasonable as far as a accommodation like service animals and companion animals is just something that we could talk about for days at a time.
Yeah. Well, and the last question that is posted here is, a lot of the and I'll kind of preface, a lot of our attendees I know have multiple layers of properties and funding and financing, whether that be tax credit, of course, HUD here on this, rural development, maybe a mixture and combination of different types of sources, right, and programs that they fall under. HUD wants to see an updated transition plan done every 3 years, and have those properties actively fixing that with the alignment. And I think we're seeing closer alignment between rural development and HUD on a lot of aspects and trying to partner. Does HUD, are they seeming to have the same requirement along the lines of doing those plans? Kind of what's the updated thought process with HUD?
Okay, so that's an interesting. HUD does not require an updated transition plan on every 3 years. RD basically has said that they want to see a plan updated or implemented within 3 years. And if you haven't implemented all the things from your original transition plan, then you're out of compliance. And so effectively, after 3 years, you're going to have a property that's out of compliance, and you really need to go and do an accessibility plan. HUD does not have that, and I don't really understand why have anything kind of documentation like RD has. But the fact of the matter is, Section 504, which is what kind of pushes this whole concept along, requires an initial evaluation, self-evaluation, and they say that you only have to do a self-evaluation one time, and then you have to do a transition plan to correct those issues. Well, the issue is that your property changes almost monthly or yearly. I mean, you have parking lots restriped, you have thermostats moved and changed, you have faucets and door handles changed out. Your property can get out of compliance really quickly. And so while HUD is silent on that, the fact of the matter is that HUD expects you through Section 504 to be in compliance. So if you're not in compliance, you need to have a transition plan to do that. And transition plans are only good for 3 years. You can't go, and we've been into hundreds of properties that we go and say, have you had a transition plan before? And they said, yes, we did. We did one in 1988. I said, can I see it? And they pull it out, and I had to blow the dust off of it because they did it in 1988, but they didn't do any of the items that the transition plan required them to do. So just keep in mind that your property is pretty much always going to be out of compliance. And if you have done an accessibility plan or a self-evaluation transition plan and are working towards getting those things completed within a 3-year period, then you're probably going to be okay from a HUD standpoint. The minute you go after 3 years and you haven't had any movement on the issues at your property, or you have additional issues at the property, you're going to have some problems. Not only the fact, just from a HUD standpoint, HUD has requirements, but not only that, you've also got issues with the Department of Justice. Any of your residents or any of your people that are coming out to lease your property have the ability to sue you if you are out of compliance in any form or fashion. So that's kind of why I'm big on pushing to make sure that you have a current and constantly updated self-evaluation and transition plan.
Perfect. Appreciate that clarification. Obviously, we've come up on our time here. I'm sure you all are wrapping up your brunch or your lunch, and but just wanted to just say a few things, and then we're going to do a quick little drawing as well, just in our fashion. We've shared just a quick overview. If you do have questions about anything that Greg spoke about here, you want some further clarification, we of course are always here to have those one-on-one conversations. And then of course, should you need assistance on your properties with transition plans, capital needs assessments, property inspections, file outs, please let us know. I'd be more than happy to talk with you about that. Remember our next one in 1 month on the 14th, so a couple days earlier, same time, is Fair Housing 101. So we're going to dive a little bit deeper into the aspects of fair housing and just different regulations around that. As far as the drawing goes, I threw in the slips of paper into my trusty little drawing hat here, and we have Jonathan Holway with National Church. So thanks for joining us today. We look forward to being there as a partner for you, and we really hope that you find these sessions valuable. Should you have any ideas and topics that you would like us to dive into further for another month, please reach out. We are more than happy. That's big part of us giving back to the industry and helping to educate and answer those questions. Have a wonderful day, and we appreciate your time.
Hi, guys.